Welcome everybody. Thank you for coming along to today's YESI International Fellowship talk. I'm Steve Levitt. I'm the director of the University of York Sustainability Clinic, which, if you haven't heard of it, it offers final year students and postgraduate taught students the opportunity to do a module for credit where they work on real climate problems with small businesses, NGOs, local government, and they bring together their multiple perspectives to the problem and produce some kind of output for the partner at the end of the module. So it's truly multidisciplinary and a very interesting exercise, which I can talk for hours if you want to, but that's not why you're here today. I'm delighted to be here today with Professor Dr. Mirjana Drenovic-Ivanovic, who is a colleague that is from the University of Belgrade in Serbia, from the law school there. And she and I are sharing the YESI International Fellowship. Mirjana is a full professor of environmental and climate change law at the University of Belgrade. She also holds the Jean Monnet Chair in Environmental and Climate Change Law, and she founded both the Environmental Law Clinic and the Master's Course in Environmental Law. She was awarded the OSCE Mission to Serbia's Person of the Year for 2023 for her contribution to environmental protection and human rights. And she has over 18 years of experience, having conducted research at Oxford as a Chevening Scholar and at Harvard as a Fulbright Scholar, in both cases focusing on access to environmental and climate justice, human rights, the environment, and sustainability law. She's advised international organizations like the OSCE, the Council of Europe, the UN, and the IUCN, and she was appointed to Serbia's EU accession negotiating team, where she coordinated multi-sectoral dialogue and drafted key environmental negotiation documents. Her legislative work includes aligning Serbian environmental law with EU acquis and developing training programs for judges and prosecutors, which is delivered in numerous national and international settings across Europe and Asia. And in 2023, she founded the Environmental and Climate Law Hub, promoting sustainability law and capacity building. She also contributes to the Council of Europe's international and regional projects on human rights and the environment and the UNDP's Global Judicial Training Programme. So more than qualified to speak on the green agenda and sustainable connectivity in the EU accession process. So Mirjana, I'll hand over to you.
Dear colleagues and dear Steve, thank you very much for this introduction, and thank you very much for the invitation and cooperation in setting a new model of sustainability clinic that we would like to develop at the Faculty of Law and University of Belgrade in Serbia, and that is very well developed with very interesting results here at the University of York. And of course, thank YESI program for invitation and for support this change of ideas, of sharing models and knowledge that will be very, very helpful for us in the Faculty of Law in Belgrade. And thank you also for your interest in this talk and topic on green agenda and sustainable connectivity in the EU accession process, to which I would try to explain how actually the process of harmonization with the EU acquis going on in countries that are not EU member states but negotiate throughout the years to become member states, and actually how we handle the recently developed sustainability directives at the level of European Union. So let me just start with this slide presenting all the countries that became member states through many waves of enlargement. And while I was negotiator, I wanted to explain and to publish an article on negotiations and what is behind relevant for the environmental protection and climate change. And with the help of my colleague, I developed a paper on many interesting, explaining many interesting details of that project. But also through that research, we very deeply looked in all those accession negotiation agreements in order to see in which period and in how way environmental protection and climate change was treated. So if you look at all those countries and look in accession negotiation agreements, we may actually notice that there are three different waves of enlargement, EU enlargement, and in each wave, European environmental protection was treated differently. I would say that the first enlargement period would be from 1972 until 1986, where actually environmental considerations were minimal or absent. And if we look deeply in those agreements, we may notice some protective provisions, but the focus was on technical and economic integration. And we may not notice that environmental protection was a big deal or issues of interest in negotiation periods, in negotiation processes that period of time. But if we know now that it is also a period when environmental acquis started its development, it can be quite usual and self-understanding. Something that is interesting is that in that period we had specific transitional agreements that should have helped new countries that became EU member states to adapt to internal market. And today we use those transitional measures a lot in environmental protection, but in period, for example, for Spain, we had 17 years adjustment transitional period for its fishing fleet, but it was not in order to protect fish or nature. It was to actually adjust to union fishing policy. So it looks like something interesting, but in terms of environmental protection, unfortunately, no. But after that, we have very interesting enlargement period, 1995 to 2004, where environment gained prominence. And when countries like Sweden, Finland, and Austria joined, what was interesting in this period, it was that those countries had very well developed environmental protection, especially in certain areas. And they wanted to maintain those higher environmental standards that went beyond EU commitments, but as such create obstacles to free movement. So they wanted to keep, but wasn't able. For Sweden, for example, it was important to keep the strict chemical regulation. And because of that, Sweden put the negotiation on environmental protection as the first phase of goals and interests in that negotiation process. And for Finland, it was important to retain higher standards on hazardous substances because, again, of their national structure. And for Austria, Austria actually was feared that there would be environmental damage to alpine areas from increased EU transport, which they regulated and stopped in certain periods of time, but as a member state, stopped to be able to do it. Although those countries couldn't keep their higher standards before the membership, once they became members, they actually raised the level of the environmental protection. So I will just mention that, for example, REACH regulation on chemicals were very massively supported by the Sweden, who then transposed their national higher standards to EU standards, but after the membership. And the third wave in which we are now is the wave of enlargement from 2004 until 2013, but still very relevant for the 10 countries that are negotiating for EU membership. It is a period of massive enlargement, but this time there are a lot of countries with less developed environmental protection. And those countries struggle to transpose and implement environmental standards. And because of that, European Union and European Commission, who negotiate in front of the European Union, decided to split the process in two different parts, to follow transposition and to follow implementation, which for me as a lawyer was very hard to understand. What does it mean and where is the difference? Transposition means that everything that is in directives of European Union must be in your national legislation on the day of the accession. So everything that are in directives should be in your national law. But implementation means that you really have to manage the work and application of all those standards in reality in your country. So through this period, we got a possibility to negotiate on transitional periods. And those transitional periods are the periods that would allow new countries to have transposition, full transposition on day of the accession, but to negotiate of certain terms through which that country will be able to prove real implementation of those standards in certain years after the accession. And also the focus was shifted in negotiation process from technical standards and standards of, for example, environmental protection and many other areas on which we negotiate, to the very basic issues like rule of law, protection of human rights, and the possibility of states to develop economic structure and to prove that it will be able to work on the common market. And in that phase, we are today, and all 10 countries that negotiate actually has this transposition and implementation system now with focus on rule of law and economic stability. As explained, it was very hard from the perspective of negotiator to write an article with a lot of data from inside the negotiation process and still to keep the confidentiality. So I put everything that was officially published then, and now there are even more data. But if you're interested maybe in this first period explaining which country struggled with which environmental issue, one may find a very interesting article published in Common Market Law Review in 2019. However, this is the list of so many different things that has happened in Serbia since 2011, when we started to think about the process of transposition and implementation of more than 300 different papers and different sources that are linked with the environmental acquis. And we developed our part in terms of harmonization with the law. And we are still somewhere on that part. I would just say that negotiating team, that we opened our procedure for negotiation in 2014, that we opened a negotiation chapter dealing with environmental and climate change in 2021. And we are now in 2025, and we are still negotiating on many different chapters, but especially on this chapter as well. How we actually prepared our negotiation position. If you look how usual negotiation position look like, you will find a paper of 7 or up to 10 pages. And that is negotiating position for any other chapter. But for environmental and climate change chapter, we developed a negotiation position of 1,500 pages. And we were very sorry, but there are a lot of explanation why we did it. Because actually, we identified investment-heavy directives. And we actually knew that we would ask for transitional periods for those directives. What we wanted to do is to explain how many time we will need to have full implementation, but also from which sources we would cover that development. And we provided 11 directive-specific implementation plans that is now base for our negotiation. Also, we actually realized that there is a lack of administrative capacity and developed a plan immediately, which new capacity will be needed for it. And also we have a lot of different issues like how to support financial plans and link them with the negotiation. Because when you're a government, you have a budget that will last 1 year. But those direct specific implementation plans means that you must engage financing system in 5 to 10 or in some cases 15 years. So in order somehow to find a link between and to solve that issue, we also developed multi-annual investment and financing plan that is still in operation and very helpful in monitoring our process of harmonization. So here is the list of those different documents and sources that are part of 1,500 pages of negotiating position. Thanks to that, actually, European Commission for the very first time decided to open this chapter, but without opening benchmarks. And we are the very first country to open negotiation on this complex chapter without opening benchmarks. But eventually we got closing benchmarks and we will see what we'll do. Of course, opening of the chapter was very welcomed by European Commission and European Union, and we were very happy at that time. Among closing benchmarks, there are many benchmarks that are highly technical, like, for example, benchmarks dealing with air quality or climate change or GHG permitting emissions process, etc., etc. But there are a lot of benchmarks actually for which I'm not sure how it would be possible to prove the good or the bad implementation. Like, for example, in processes of environmental impact assessment and public participation in issues that are relevant for access to environmental justice, we should actually prove that we are able to demonstrate that by the date of accession, it will be fully prepared to ensure effective implementation and enforcement of horizontal directives, but without any indicator how to prove that. So we have now a lot of good examples of access to environmental climate change justice, a lot of very good and highly qualitative decisions of the highest courts. But at the same time, we have very bad implementation in certain areas, in certain examples. So how to use it for this purpose? We will see what will be done. The next part, how we will continue with this, is very relevant for involvement of sustainability issues in this process. And approach of the European Union helps us a lot here, because in 2022, they changed their methodology on negotiation and said, well, the process is very slow down, so we should speed it up. And instead of negotiation chapter by chapter, we will negotiate on a cluster basis. What does it mean? Why is it relevant? It is very relevant because now each issue from environmental climate change chapter is discussed also at the same time through the energy issues, through the transport issues. So now there is no need to negotiate double or 3 times on GHG reduction going through different directives, but it is a way to negotiate immediately under the cluster called Green Agenda and Sustainable Connectivity. And many new sustainability directives should be discussed under this umbrella framework. Also, in 2020, economists of the Western Balkans developed a green agenda for the Western Balkans that actually should follow the goals promoted by European Green Deal. And a very important part of our future transformation and especially addressing of sustainability issues is linked with that document. Also, it is important to know that our documents and growth plans are linked with the change of European Commission goals. And just if you compare that change, for example, if you follow the Commission priorities 2019-2024, a European Green Deal was at the top of the list, but those are new political guidelines, and we do not have any more European Green Deal, but rather build a clean industry deal to decarbonize, meaning again cluster approach, or invest massively in sustainable competitiveness, which actually is the base for faster and better implementation of the sustainability, recently developed sustainability directives. So also we developed our growth plan for the Western Balkans, and Serbia and other Western Balkans economies did the same, which is important because now we have opportunity to harmonize and to develop and to involve sustainability goals, but funded by the European Union, at least and at this part while we still negotiate. Now I will go to a part where I would like to explain how we actually approach to recently developed EU directives in the field of sustainability, especially corporate sustainability. Having in mind that our negotiation position actually provide a plan for the transposition and implementation of environmental acquis, set into account on the date 1st June 2019. But since 2019 until today, we got so many new, very important directives. And here is just a very short list of those directives that started to be important for us. In the field of circular economy, in the field of supply chain, in the field of reporting and financial rules. What we actually currently do is that we are trying to find our unique model. For many of those directives, we do not have a specific law. Neither those directives are analyzed through a negotiation process. But actually, having in mind that many of our companies closely cooperate with European Union companies, many of the standards in the last two years started to be part of businesses policies in Serbia. And also there are some very tricky and interesting directives, or regulations for us, like regulation on critical raw materials. Having in mind that one of the project that is under specific public awareness, which is a project on extraction of the lithium. Just a couple of days ago was pronounced to be strategic project for the European Union. So we will see how will deal with that, having in mind that the relevant procedures on environmental impact assessment and any others related to the other project have just been started in Serbia. So yes, it is up to criteria that we have already developed to decide whether this project should be developed more or not. But that is just one more issue that we should think about. I will just now provide a couple of examples how we manage to implement those new regulations. For example, let me start with the taxonomy regulation. For those of you who do not work with the taxonomy regulation, I would just like to stress that it establishes a unified classification system for environmentally sustainable economic activities, meaning it provides standards under which you may, as a company, say this is in accordance with the sustainability goals, or this is sustainability way of doing things, or it is not the case. And in Serbia, throughout 2023 and 2024, we started to change regulations in order to include projects with minimal environmental impact, or to include in a foreign investment system that part of you should do in accordance with EU taxonomy. And there are some interesting acts. We do it very in a soft way. So we change maybe one article, half of article, but actually it is something, it is start where sustainability and taxonomy start to be relevant. Again, it is important to stress the sustainability finance disclosure regulation. That requires financial market participants and advisors to disclose how sustainability risks are integrated into investment decisions. Also, we do not have a specific law on it, but our Chamber of Commerce started to involve voluntary measures for our business society. And at the Faculty of Law, we also started a number of programs to introduce the system of this SFDR regulation, and also to educate public, but also business society on implementation and use of new ESG standards in their work. However, as you may notice, this is all market-led, I would say, adaptation rather than government-led. But I would like to say that it is very important in those questions where you have a big puzzle to use each momentum that can be used. And this is the time when actually business society realized that it cannot work with companies in the internal market without respecting all those standards. So it is not important for them anymore whether it is a part of national legislation or no, but whether they must do something about it because of, in this case, regulation of the internal market. What else we can do? We can actually start to thinking about how to use institutes that we have, legal institutes that we have in our national legislation, in order to reach some better decision making. And for example, I here provided one example that I'm extremely proud of, where we had one powerful electric company, and under the national reduction emissions plan, that company should have reduced the emissions for some amount, 30%. It is irrelevant for us. But they didn't want to do it, and year by year, not only did they reduce, but they increased their emissions. So many stakeholders, citizens, NGO, environmental NGOs started to write petitions, started many procedures, ask inspection to do their job without result. We had a massive silence of the administration. And one of my previous students, now very developed lawyers, started to use our example that we discussed as hypothetical case, where we had for 44 years one specific article in our law on contract and torts, where actually in certain circumstances one can use actio popularis claim and ask nothing more, but that is enough, certain activities to be stopped. And they use it for the very first time. The lawyers from our legal clinic, environmental law clinic, was behind that environmental NGO, but at the same time, the lawyer who worked with the judge also was our ex-student. They actually did a very good job. It is a decision quoting too many decisions of the environmental European Court of Human Rights, but also comparative legislation, etc. So they did it. They use it 44 years after it was actually prescribed by the law. And now is the idea to tackle all those issues and to find to link them with the existing legal institutes that we have in our regulation. For example, to use more corporate liability through a system of consumer protection law, which is very well developed, for example, in Serbia, but also in Western Balkan region, but was never used for access to environmental justice or access to environmental information. And there are so many, this is just one example, there are so many issues that we would like to try to solve through this concept. And of course, development of sustainability and involvement of sustainability in law curricula, and understanding of environmental and climate risks will be of crucial importance. So I'm very happy that Steve will be in Belgrade in September, October, and that we will have opportunity to work on this together. And I will stop here, and thank you very much. I'm very open for your questions.
I should have said at the beginning that if anybody has any questions online, they can use the chat function in order to write those, and Rachel, who's here from Yesi, will pass those through to us as we go along. Are there any questions in the room at all, or anybody online?
Yeah, although several, I don't quite know where to start. Okay, I'll start with this one. So you know how a few years ago the EU made the pledge to restore and protect 30% of terrestrial ecosystems and marine ecosystems. And then that got, I think the 30% figure basically got adopted internationally from, I think, the Commons Montreal Global Biodiversity Framework during the biodiversity COP talks a few years ago. So how, given that it's like the EU went 30% of habitats that we want to protect and 30% that we want to restore that have been degraded, how does that practically work then with all of the negotiations and legal things? And how is it, because obviously some countries that are landlocked won't be able to nationally do anything about the protecting ocean habitats, because they're like, well, they're not in our country or whatever. But I assume, like, how does that stuff work?
Yes, if you remember one of many slides, I'm sorry, geographical adaptation. We actually went through a very demanding process of adaptation, and we explained what is and in which way possible to do in next years. after the negotiation process. So we started to implement that plan. We are unfortunately at the very beginning of it, but it is very important part also for negotiation position to choose the location, to actually understand the possibilities and to make a plan. Realistic one.
Do countries have to, is it like the countries contribute towards like a collective plan, or does it get divided into each country, you figure it out by yourself?
Country by country.
Okay, yeah.
That's why we have this geographical limitation in the process.
Yeah.
So it's for now at this level only country by country, because we are negotiating. No one guarantee anything from the European Union, so we do not know when process will be ended, whether we will be a member state or no. We actually do not have any kind of information, which is unusual for negotiation system, but that is the way the system works.
Okay.
Thank you.
Rich, I saw there was a comment on.
Yeah, we have a question from Sean Thomas. Do you want me to read it out?
Yeah, please.
He said, thanks for this fascinating talk and apologies that I'm not being able to come along in person. What would you say is the argument that a lot of the changes pertaining to circular economy / sustainability are unlikely to have substantive positive impact because of the privileging of IP rights within the doctrinal frameworks?
Yes, I explained how we actually plan to manage it, but also some recent decisions from the part of European Commission are not on our side. I must stress, especially having in mind the conversation that Sean and I had during the previous seminar. Just a week ago, I said that directive on the use of green claims should support better access to environmental information over a system of access to environmental information as information of public importance. And I stress that this directive actually can connect many different directives, but for example, just 2 days ago, European Commission said that they will think about whether to continue with the trialogue on this directive. And that is just one example. Then the change in positions through omnibus package and et cetera. So that's why I stress that this is a market-led process, and that we actually use the momentum where the business society realized that they should do something about those legislation, which is not a part of the national legislation yet.
Okay, thanks, Miana, for the very insightful presentation. My question, I'm thinking of the EU. The EU is a very key partner, not to only the Western Balkan countries, but even Africa. And my question is, how, just in your opinion, what do you think the impact of the environmental standards that are being set up by the EU going to impact African economies? And particularly, I'm asking this from a position that says we want to limit the risk of, green protectionism, which may affect developing economies like those in Africa. I think you saw in my presentation again, most of the sugarcane expansion is largely driven by EU demand and funding. And of course, it has those repercussions. I'm just if you can provide something.
Yes, that's why actually I put this just after your presentation, this about the Yano project, because I wanted to stress that it's not one idealistic picture and approach, and still we will have to manage to struggle with so many issues in order not to be just left alone somewhere in the middle of the process with big construction projects that would go on. But I mentioned the example of Austria, Sweden, and Finland. While they were not a member state, they couldn't do anything. So if you're not around the table, you cannot do anything. Like we are now, we are negotiating. We are never around the table when very important sustainability issues are discussing. But if we become, maybe we can affect not only the change, but also the consequences that would be in front of us. At this position, there are a lot of consequences in front of us, but I'm afraid at this very moment, we cannot change the regulation or influence more, unfortunately, as a very small country. Thank you.
Questions from the room? Can I just ask a question? It's kind of a follow-up to that one. Do you mind if I
Yeah,
just
go for it.
jump in for a second? So I'm quite interested in, perhaps you could say a few words about where Serbia is in terms of its accession position, because obviously we were talking about the levels of protest in Serbia at the moment, and from what I understand, the protests are a mix of concern about corruption and the collapse of the station in December last year, and some hostility towards Russia and some anxiety about going into the EU. So where does Serbia sit at the moment? And what extent, you mentioned Serbia being a very small voice. I wonder if you could say a few words about the lithium extraction position as well, because I wonder whether that's about Serbia being rolled over by the EU in its search for resources, a little bit like with Africa.
Yes, well, I mentioned that the focus in negotiation process was changed, and the rule of law is something that is a base. And many times throughout the negotiation, I negotiated on the chapters dealing with environment and climate change. But the process, although we had very good energy and transposition, but the process was slowed down or even stopped because of the lack of the rule of law. And I'm not in negotiation process anymore, but I believe that we can notice a slowdown now even in those issues. And we will see how it will develop in the future. But concerning the lithium project and the issue, actually it should be one of the biggest European projects in extraction of lithium. But in the area of Serbia, when you have a lot of drinking water, according to some scientists in Serbia, that project can have a very bad impact on the quality of water that we cannot then use. And this project has been developed since 2004 and now should be in a final stage, but we have a massive public protest throughout the country because people are not satisfied with the information that they ask and do not receive about the whole project. And the crucial procedure is environmental impact assessment procedure, through which we should see scientific evidence of whether and which kind of bad impact on the environment the project might have or will have. What can be reduced, what cannot be avoided, etc., etc. But in the middle of that, we have the decision of the European Commission to declare this project as a strategic project, meaning that all the procedure should be speeded, and that it would be easier for the company to gain financial support from different international investment spots. At the same time, as I understand the situation as a lawyer, it doesn't mean and cannot mean that we must speed up the procedure in Serbia because we are not a member state and we have our own procedures. But anyway, that move that in the middle of something that produce critical position for all stakeholders, you decide just to declare this project to be strategic. It is quite, it opens a space for discussion.
That's very diplomatic. Maybe you could say provocative. Possibly.
Well, I was negotiating for 6 years, so.
Yeah. Sorry, you had a question.
So in your experience and your research, do you think the pace of people of people in the EU, of key deciders in the EU, taking more seriously the need to protect the environment, restore degraded habitats and all that? Has it been kind of accelerating? Because as at the start of the presentation, you were talking about the 70s and 80s, and it wasn't really talked about. And then it was being more talked about through the 90s and onwards. Has it kind of accelerated in terms of people caring about it? And have key kind of big lawsuit examples, such as the 6 Portuguese youth who tried to sue the entirety of the EU, although then were later told you should have gone to your own government first, which I thought, why did it take them so long to be told that? But anyway, and then a group of women in, it's either Sweden, yeah, who successfully managed to win a lawsuit case against their own government about, the disproportionate ill effects of environmental pollution on women, older women, and all that. Do you know if those like lawsuits have kind of had an effect on the urgency of doing these negotiations and implementing things and figuring out how can we actually meet at the targets that we've set? Like, have they made a shift? Have they? What's your perspective on
Yes,
that?
thank you very much. We actually have 2 approaches. First, for example, in 2004, we set into account the most important horizontal legislation, meaning for the very first time, we regulated the procedure of environmental assessment. That procedure officially guaranteed public participation. So it was in 2004. And when I started to research this area in 2010, I could find only 2 examples where public really decided to take part in decision making. And I asked why, and got the explanation because they don't know that they have rights, and no one explained and communicated that to them, etc., etc. And that's why we started to develop so many programs at the Faculty of Law for the students, future decision makers, future attorneys at law, future judges. But at the same time, we started to educate judges and the prosecutors about, first, scientific background. So it is not something just funny or something for nice people to deal about, but this is something that actually affects our everyday life. So I cannot decide today not to breathe. And in some areas in Belgrade, I received that information just today. It is dangerous to breathe. So we have some information, announcements stressing that you should not go out today and take a walk because it is dangerous. That is the official formulation. So through those different channels, and also we clustered environmental NGOs, educated them, provided toolkits, everything that was needed by them in order really to start to be a part of decision making.
Was that legal education? Was that to
Yes.
educate on your
Yes.
legal rights? Yes. Yeah. Okay.
Legal
Yeah.
education. And now we have results.
Okay.
For example, if you have 100 different environmental impact assessment procedures, in 90, we will have massive public involvement in environmental decision making, etc., etc. And for example, some of decisions of the highest administrative court and their understanding and discussion about environmental issues are at the level of, for example, constitutional and administrative law that I can have opportunity to read from Germany or European Court of Human Rights. So at the very at the highest level. I'm using these countries because those countries because our background in So so big change.
Okay, so is that making the regulations, is that kind of giving them a nudge to say, we need to get on with forming our regulations, making our business practices and regulations for European businesses more environmentally friendly? Have these kind of legal changes given the push?
Well, education of all stakeholders, because you must also educate business, business society, but also you must be honest and find a way to communicate. For example, if you really want green transition, energy transition, you need critical raw materials. There is nothing wrong with that. And it is also something that must be understood by all stakeholders. But why are trying to deal with critical raw materials, let's not allow to demolish the system of public participation or proper access to market justice, etc., etc. So everything must be balanced, and the point of sustainability education is exactly that. We have so many parts of the puzzle that we must think about when we actually articulate what we actually want.
Am I right in thinking as well, sorry to interrupt, but your question kind of, is it about how businesses have responded to the climate crisis within the existing EU, or do you mean within Serbia as an exceeding?
Oh, just the EU in general. I'm just wondering about if the high profile lawsuits have had an effect on regulators, on the key decision makers within the EU, who, you know, whether it's sort of, whether those are almost like key flashpoints of, there was a big legal challenge, one of them won against a particular country, and one of them didn't win in the end, but it still got high public and media attention. And lots of crowdfunding and people behind it. So have those kind of flashpoints of big high profile legal challenges, have they kind of given almost like propelled the progress on certain environmental standards being implemented or raised or that kind of thing?
Well, that's very interesting. I think in some respects it's probably too early to say whether or not those specific cases have done that. I mean, I'm not an EU expert and I'm not an environmental law expert either, but I am a lawyer, and I would say that the flashpoints really that drive change are not related to legal cases.
Okay.
They're more often related to political situations. So what's the big driver at the moment? Big driver at the moment is gas, oil prices, threats in the Middle East, threat to supplies from Russia. Those kinds of issues are what really will change the way that business is done in the EU, either positively or negatively. It's more likely to result in a rolling back of some of the environmental protections in a desperate rush to maintain energy supplies that will enable us to continue to work in the way that we've always worked, whilst at the same time maybe accelerating some of the transition work that we've done around new forms of power supplies, which are perhaps greener. But I as a lawyer, I tend to be a little bit cynical about to what extent legal challenges do impact and drive things forward. I think sometimes they are really useful at helping to frame the discussion. So what interests me with Serbia, I think, is that Serbia comes from a low base of environmental protection. I think before it began the accession process, and then as part of the accession process, they've now got to think about changing their laws. So I think law plays a role in developing the narrative rather than necessarily actually being the thing that provokes the change. So I don't know how you.
Yes, but each of big moments like energy crisis or anything else that you actually mentioned generates and generated a new regulation at the level of European Union. And we can see here that we have so dramatic changes. For example, before Ukraine war, EU member states started to decrease the use of nuclear energy. And then overnight, they needed only a month to develop opposite plan to increase the use of nuclear energy. So each of those issues dramatically influence environmental protection and those regulations.
Did COVID-19, what effect did that have?
Yes, also the crisis and the position of the public in decision making, it started to be very important.
I think also to a certain extent, issues like, so the fact that a process can be developed to enable a position to be taken more rapidly in response to a crisis, then means that that process is available to help speed things up in the future. So if you can do it quickly in relation to a crisis where you have to move back to nuclear, then why can't you do it more quickly in relation to developing wind power and so on? So I think sometimes those are the impacts rather than necessarily,
Right.
you know, kind of the specific
Yeah,
decision
kind
itself.
of revealing what can be done when you need to.
Yeah,
I mean, that was, I heard so often people reflecting on the rapid response during the pandemic of certain nations and going, so we can, I mean, even the joke of there isn't a magic money tree and then suddenly there was a magic money tree, you know, kind of like, no, that makes sense, yeah.
Yeah.
But
that's
also
fair.
it is relevant that you cannot make fast changes in environmental protection. You need many years to see the results, and you
Yeah,
cannot just
yeah.
change it
For some of them,
every
yeah,
year.
it's habitat
Yeah.
restoration,
Yes.
some of them, yeah.
Yes,
Yeah.
and because of it also it is quite tricky for the politicians because whatever they do, the results will not be seen during their mandate, but after that. So they usually decide not to be so,
Yeah,
not to push development of regulation.
We've just got time, I think, for one more question if anybody wants. It's desperately either online or. Okay, well, look, I'd like to thank Mirjana for a very illuminating talk. It's fascinating to hear about the process of a small country. Serbia is relatively geographically small and in terms of population small, particularly in comparison to the size of the EU, and coping with that imbalance of power must be really complicated. And I guess it's not surprising that it's taking the population a while to make up its mind about what it actually wants to do with the process ultimately. So yeah, I wish you every success. But yeah, if we could just thank Mirjana.